Hello, and welcome to this webinar on key issues for businesses arising from the UK's new relationship with the EU. The Trade and Cooperation Agreement, or TCA, between the United Kingdom and the European Union was finally agreed on the 24th of December 2020. It's been implemented in the UK by legislation, and following ratification by the European Parliament in April, is now fully in force. Under the TCA, there are no tariffs or quotas on goods moving between the UK and the EU, provided the relevant rules of origin are met. But the TCA permits non-tariff barriers to trade, and these may increase over time with regulatory divergence, which is a key priority of the UK government. The agreement also contains detailed provisions on many areas going beyond trade and customs. In addition, it provides for further negotiations and refinements. For example, there are joint declarations already on financial services and data adequacy and subsidy policy. The TCA is subject to review every 5 years and to regular sectoral reviews. The political context of any such discussions will be important. As has been widely reported, there's tension at the moment between the UK and the EU over the implementation of the Northern Ireland Protocol to the 2019 withdrawal agreement. The EU has taken infringement proceedings against the UK in relation to the UK's unilateral suspension of the so-called grace period for implementation of the provisions of the Northern Ireland Protocol. And the co-chief of the Partnership Council, Lord Frost, recently said that the protocol is not sustainable for long in its present form. And it's far from clear how this will be resolved. In the meantime, UK exports to the EU fell significantly in the first quarter of this year, and it's not yet clear to what extent this is the result of teething problems or the pandemic or longer-term structural adjustments. In reality, it's probably all three. Other areas in which immediate effects of the new relationship have been felt include cross-border provision of services and mobility of people. Against this backdrop, it's not clear how much of an appetite there will be for further regulatory alignment in key areas such as product regulation. In a related example of how the landscape's evolving, a draft regulation on foreign subsidies published recently will confer on the Commission major new powers that could ultimately be used against the UK. Much therefore remains uncertain about how the UK's relationship with the EU will evolve, and this will require ongoing attention of businesses. Turning now to the structure of the TCA, this slide illustrates something of its breadth. And the next slide illustrates something of the scope of part 2 of the TCA, although it doesn't illustrate the labyrinthine nature of the exceptions and carve-outs that pepper the TCA and the annexes. One commentator recently described this as like some kind of sick Easter egg hunt that trade negotiators are sending us on. In addition to the general and sectoral review clauses that I mentioned previously, there are a number of deadlines and milestones anticipated in the agreement, and some of them are set out on this slide. This slide seeks to illustrate the concept of retained EU law. This is a body of law consisting of EU legislation that had been implemented into UK law before the UK left the EU, as well as directly applicable rights under EU regulations, as well as certain general principles of EU law and case law. It's subject to provisions of the withdrawal agreement and the TCA, and in any given case, it's necessary to consider whether UK domestic legislation has changed that body of retained EU law, or indeed whether it's been changed by international law. So a very complex landscape. Turning briefly now to the institutional framework, the TCA will be implemented by various committees operating under oversight of the Partnership Council, co-chaired by Lord Frost and a Commission Vice President. Those committees couldn't be established until the agreement had been ratified by the European Parliament, but it's reported that this is now underway. The structure is complex and unwieldy, and overall we are, according to the UK, in a changing Europe, looking at a morass of committees, review dates and discussions. And finally, dispute settlement. The TCA contains a complex dispute resolution mechanism governed by public international law and backed by draconian powers. Private citizens or companies cannot rely on the provisions of the TCA in domestic courts, in particular the EU obligations in relation to the non-imposition of tariffs and quotas are owed to the UK government. And with very limited exceptions, there is no role in all of this for the European Court of Justice. We're now going to turn to a case study that will illustrate some of these aspects. As this slide is intended to illustrate, the case study involves a UK-based manufacturer of chemical products. In the first part, Paulette will explore the trade and customs issues relating to the import by the producer of raw materials from the EU and the treatment of finished products that leave the plant and are supplied to customers in the UK, Northern Ireland, and the EU. Each of the subsequent speakers will introduce another aspect of the case study, as illustrated by the slide. Now over to Paulette.
Thank you, David. The Trade and Cooperation Agreement, or TCA, is a free trade agreement rather than a customs union. This means primarily, in the first place, that the UK and the EU are free trade partners and customs formalities apply for trade between the EU and the UK as they do between the EU or the UK and other third countries. Second, there is no common external customs tariff. This means that the UK can implement its own trade policy. It not only therefore decides on its customs tariff, but also is free to conclude free trade agreements with third countries. The same is true for the EU. Third, as David already says, goods moving between the EU and the UK are subject to customs duties at customs clearance in the UK or in the EU, unless they have origin in the UK, respectively the EU, or other special customs regimes apply. The conditions to acquire and evidence such so-called preferential origin are set forth in certain articles and annexes of the TCA. Basically, goods will originate in three cases. First, when they are wholly obtained in the UK or in the EU. An exhaustive list of wholly obtained products is provided for in Article Origin 5 of the TCA and covers, for example, plants harvested in the EU or the UK. Second, they will also have originating status when they are made exclusively from originating materials. We know that if a product has acquired originating status, non-originating materials used for its production are not considered when that product is incorporated as a material into another product. Third, and that's the more complex issue for origin rules, originating status for goods will also be obtained when they are made from originating and non-originating parts of materials which have undergone sufficient working or processing in the EU or the UK. Whether sufficient working or processing has been carried out is defined by reference to the specific product rules of origin. These product-specific rules of origin consist in what we call list rules for each product identified by tariff heading. These rules detail the minimum working or processing that must be carried out on non-originating materials for a product to qualify as originating. These list rules typically require a change in tariff classification, either at the level of the first 4 digits of the tariff heading, or alternatively, a change at the level of the 6 digits of the tariff heading. A specific production process, a maximum value or weight of non-originating materials, a combination of these factors, or factors as the above, but formulated in the alternative. If we take, for example, a product X that is manufactured in the EU, say disodium carbonate as a raw material entering in the manufacture of product Y, manufactured in the UK, we find that the duty rate of 4% applies for third country imports of products X in the UK. Therefore, in order for the disodium carbonate coming from the EU to benefit from a 0% duty rate in the UK under the TCA, the specific list rules for disodium carbonate must be satisfied. In this case, this means that either of the 3 criteria under the product-specific rules of origin for disodium carbonate must be fulfilled. And I refer to, in the first place, the tariff heading of the disodium carbonate must have a 6-digit tariff heading different from the 6-digit tariff headings of all the non-originating materials entering in the manufacture of the product X, the disodium carbonate. In the second place, as an alternative, the production of the disodium carbonate must undergo in the EU a specific manufacturing process, which is defined in this case, and I quote, as a chemical reaction, purification, mixing and blending, production of standard materials, a change in particle size, isomer separation, or biotechnologically processing. And third and last possibility to obtain originating status for the disodium carbonate is the maximum value of the non-originating materials entering into the EU production of the disodium carbonate may not exceed 50% of the X works value of product X, i.e. the finished disodium carbonate. In case the product-specific rules of origin are not complied with, the 4% third country duty rate will become due upon importation of product X into the UK. As a practical note, it's also important to bear in mind that preferential origin of imported goods can be established by two means of evidence, either a statement on origin or importer's knowledge. The statement on origin consists in a text to be affixed by the exporter to an invoice or any other document that describes the originating products in sufficient detail for the identification of that product. Alternatively, the importer's knowledge must be based on information available to the importer that demonstrate that the product is originating and satisfies the requirements set forth in these list rules that apply to it. Let us now assume that company B uses product X to manufacture product Y in the UK. If product Y is sold in the UK, no duty will of course apply. However, if product Y is sold to customers in the EU, we once again have to check the TCA and the specific rules of origin that apply to the finished product, i.e. product Y. For a product Y filing in tariff heading 3402, the TCA provides again that origin cannot be obtained based on 3 alternative origin criteria, and these are the same than the origin criteria that already applied to product X, the disodium carbonate. As a matter of fact, this is a coincidence because oftentimes the list rules for the finished products will be different from the list rules of the non-originating materials entering into this finished product. We can see in the EU's combined nomenclature setting forth tariff headings and customs duty rates that the third country duty rate, referred to as conventional duty rate, is 4% for the products of tariff heading 3402. If the product-specific rule of origin that we just mentioned for product Y is not complied with, the standard tariff of 4% will apply upon importation of product Y into the EU. However, in order to be complete and perhaps to complicate matters a little bit, we note that a customs regime such as outward processing relief under the Union Customs Code may allow for product X to be temporarily exported from the EU in order to undergo processing operations in the UK. The processed products resulting from these goods, product Y, can then be re-imported into the EU and released into free circulation in the EU with total or partial relief from customs duty. But this requires that the conditions of the outward processing regime be satisfied and that a special authorization be obtained in the EU. Similarly, if product X did not meet the origin requirements to obtain origin, the importer into the UK could try and apply for an inward processing regime in the EU, whereby the product would be exempt from duty at importation into the UK to the extent that the processed product, the product Y, is exported to the EU. Again, that would require in the UK meeting the special import requirements and obtaining an authorization. These customs regimes would be alternatives to obtaining duty-free entry under the rules of origin, but beware that they set forth quite heavy administrative formalities. Let's now turn to a third and more complicated sales route even, and imagine that sales from Great Britain are taking place to customers in Northern Ireland or to the Republic of Ireland. In this regard, it is important to recall that the TCA provides for zero tariffs and zero quota on all trade in goods originating in the EU or in the UK from the 1st of January 2020, but it does not cover Northern Ireland, which remains governed by the Protocol on Ireland and Northern Ireland. And specifically, this protocol provides as follows, and I will quote, according to the Protocol on Ireland and Northern Ireland remains part of the customs territory of the EU, and EU customs rules and procedures will continue to apply there. This means that the customs formalities required for movements of goods between Northern Ireland and Great Britain are the same as those that apply to movements of goods to, from any EU member state to a non-EU country. This results in very important considerations for companies with logistics hubs in Northern Ireland, including for distribution channels to the Republic of Ireland. Indeed, the protocol seeks to address concerns that Northern Ireland could be used as a loophole for the entry of goods without duties paid into the customs territory of the Union, be it the Republic of Ireland or any other location in the EU. In case goods are in free circulation in the UK, they may still benefit from duty-free treatment at entry into Northern Ireland, but must meet a special requirement that is set forth in Article 5 of the protocol, and I quote again, no customs duty shall be payable for a good brought into Northern Ireland from any other part of the UK by direct transport, unless that good, and I emphasize, unless that good is at risk of subsequently being moved into the Union, whether by itself or forming part of another good following processing. In other words, if the product coming from the mainland of the UK is entered into Northern Ireland and is at risk of moving to the Republic of Ireland or elsewhere in the EU, customs duties would be due. On December 17, 2020, a joint EU-UK committee adopted decision on the determination of goods not at risk. It lays down the conditions to obtain an authorization to bring goods into Northern Ireland by direct transportation for sale to, final use by, end consumers, which would render such goods not to be at risk of subsequently being moved to the European Union, and thus to be subject to duty-exempt entry into Northern Ireland. We can distinguish two scenarios. The first one is, in our example, if product Y, produced in the UK and in free circulation there, is moved to Belfast, customs duties will have to be settled unless the good is not at risk of being moved into the Union, be it the Republic of Ireland or any other location in the EU. Based on the decision of the Joint Committee, there are two ways to establish that goods brought into Northern Ireland from Great Britain are not at risk. And the first one is the applicable EU tariff is zero. For instance, when the goods meet the origin requirements set forth in the TCA. But the second one is indeed that the goods are for sale to or final use by end users and consumers located in the UK and are brought into Northern Ireland by a trader authorized under the UK Trader Scheme. Therefore, the most straightforward solution to move goods into Northern Ireland and from Northern Ireland to the Republic of Ireland is that the goods are zero rated, either because of origin rules or because there is a zero rate in the EU. However, if the EU tariff is above zero, then the goods brought from into Northern Ireland from Great Britain can be declared as not being at risk of being moved to the Republic of Ireland or elsewhere in the EU when they are for sale to or final use by end consumers located in Northern Ireland. To declare these goods as not being at risk, again, an authorization under the UK Trader Scheme is needed. And there are difficulties for wholesalers and retailers. Indeed, wholesalers may not be able to undertake to bring goods into the Northern Ireland solely for use to and sale to end consumers, or they may not be able to set up a physical direct sales to end consumers when they need to go through intermediate dealers. So therefore, in practical terms, in the case of wholesale distribution centers in Northern Ireland, it may not be possible to benefit from customs duty entry, and the rearrangement of supply chains for sales from the mainland to Northern Ireland and then to the Republic of Ireland needs to be considered and contemplated. The second scenario is in the case of product X, our raw material that goes into the UK for processing into product Y in the UK. Imagine now that this product X is not processed in the UK, but moves directly from the UK to the Republic of Ireland. In that case, the duties imposed in the EU on this product would normally be applied, because the goods is no longer in free circulation in the EU, it has moved outside the EU, and it does no longer meet the requirements of the TCA. However, the European Commission officials in charge of customs matters of DG Taxud have then suggested that for these products, it may be possible to use a special regime that is called a return of goods to the EU, that is set forth under Articles 203 of the Union Customs Code and 158 of the Delegated Act to the Union Customs Code. That provides that under certain specific conditions, goods that have been moving outside the EU can be re-imported into the EU without customs duties. However, these conditions are not simple to meet and will require quite a bit of verification. The guidelines in this regard are set forth in the guidance by Irish Revenue and can be examined. I will now move to a last item that I wanted to touch upon today, and that is the UK's duty suspension regime that may also offer possibilities for requesting duty exempt status upon importation into the UK. Duty suspensions are temporary tariff suspensions in order to promote the competitiveness of the downstream industries, or because this is considered in the interest of the UK, for instance, for COVID-19 related medical equipment. Tariff quotas are duty suspensions capped by a certain volume. The EU duty suspensions that were in force as of July 2020 have been carried over into the UK. These rolled over duty suspensions are in force for an initial period of 12 months and were subject to internal review in 2021. Quotas have either been transitioned or converted into duty suspensions. And indeed, the UK authorities have undertaken to set up the UK's own duty suspension regime and have finished a consultation in this regard on the 12th of March 2021. On that basis, and very recently, the UK has launched its own duty suspension scheme, of which the reference will be found in a link in the PowerPoint presentation that will be circulated after this webinar. The link to the application form and the criteria for these duty suspensions to be obtained will also be provided in our PowerPoint presentation. What is important for importers to bear in mind is that the window to apply for a duty suspension will be opened from the 1st of June 2021 to the 31st of July 2021. Therefore, importers that wish to obtain duty suspensions should make sure that within this window, they apply for the duty suspensions to be afforded. As mentioned, the EU has its own duty suspension and tariff quota regime. So at the same time, exporters from the UK and importers of products manufactured in the UK should also be verifying these duty suspensions and tariff quota to see whether their products can benefit from duty-free entry under these duty suspensions or tariff quota, or whether the conditions to obtain these duty suspensions or tariff quota can be met by new applications for these duty suspensions that must regularly be submitted to the EU authorities and then can benefit from this duty suspension. I thank you very much for listening, and I pass the floor to Stuart.
Thanks, Paulette. I'm going to look at how Brexit might have affected contractual arrangements between A and B, and where disputes might arise in future. If in the past they contracted on the basis of English law, they can continue to do that, and this choice of law will be respected throughout the EU. If in the past they provided for disputes to be determined by the English courts, they can continue to do that, but for technical reasons, it makes good sense to provide for the English courts to have exclusive rather than non-exclusive jurisdiction. But what about the substance of the agreement between them? Well, let's suppose that A and B have taken advice from specialist trade lawyers, something they may well not have thought necessary prior to Brexit, at least in relation to trade within Europe. They will know that UK-EU trade will involve greater complexity than when the UK was part of the single market. Getting a firm understanding of the detail will enable them to address in future contracts how risks such as the risk of delay and additional costs are to be allocated. But it's important also to keep in mind the wider context. We're in the early days of a new political and economic relationship. We just don't know what will happen over the next few years, but there are sure to be certain bumps in the road. To give just one example, tariffs may apply in the event that a particular good or product doesn't meet the rules of origin criteria stipulated in the TCA. In addition, duties may be imposed in the future in the event of a breach of the TCA or as a result of the imposition of trade defence measures. Parties entering into a new long-term agreement may want to deal expressly with how the UK-EU relationship might develop over the life of the agreement, for example by anticipating possible events and how they might affect performance. They might provide for price adjustments in particular circumstances, or that certain events will trigger an obligation to renegotiate certain provisions. These sorts of clauses come in different varieties, some quite specific and tailored, and others more general. The more specific the clause, the greater the risk that the event that actually occurs isn't covered. On the other hand, the price of opting for the general over the specific is greater uncertainty and a greater risk of future disputes. A possible solution is a hybrid, a clause that specifically identifies particular problems that can be foreseen at the outset, coupled with some catch-all general wording. Whatever form is selected, there could still be potential for dispute regarding whether a particular trigger event has occurred, and if so, how the clause responds to that event. But what about existing agreements that were entered into prior to Brexit? Well, Brexit hasn't really had any impact on substantive English contract law, but it may well have had a material, practical impact on the performance of the agreement. Import-export declarations, regulatory checks, other non-tariff barriers, these all have the potential to increase the time and cost involved in cross-border trade. The net effect is that particular agreements may have become more difficult or onerous to perform. Others may be affected by changes in the surrounding legal or regulatory landscape. In very broad terms, this may give rise to two types of dispute. First, where there's uncertainty regarding which party should bear a particular risk or a particular additional cost, which then gives rise to a dispute regarding the meaning and effect of particular provisions in the agreement. Whether that leads to litigation will depend on a number of factors, including the merits of each side's position, the strength of the relationship between them, and whether there's an appetite to find a commercial solution. The second type is where a particular risk or cost is addressed in the agreement, but where Brexit has changed what performance looks like in practice. For example, let's suppose that A and B have a long-term supply agreement under which raw materials are supplied ex-works. Both parties know their way around Incoterms and will understand that this means that what the seller is required to do is to make the goods available for collection by the buyer, but without these goods being cleared for export. In our case, B, as the buyer, is faced with additional costs which will feed through into the overall cost of the raw materials, pushing down the margin on the finished product. That pressure is all the more acute if the margin is also squeezed by B having to bear additional costs in making onward sales, so B is effectively being squeezed at both ends. Let's suppose that B sells to large supermarkets who insist on buying goods on terms that require B to take responsibility throughout the shipping process, including fulfillment of export and import responsibilities and the payment of any duties. B may have little or no negotiating power with its supermarket customers, so it needs to reduce the cost of the imported raw materials. What are its contractual rights? Well, provisions that B might be looking at closely are any pricing review mechanisms, and possibly at the force majeure clause. But there's no general concept of force majeure in English law, so whether this is a viable route will depend on the scope of the clause, and the fact that performance has become more onerous for one party is unlikely to be enough. B might also start to think about the nuclear option of termination, at least to improve its position in pricing negotiations. But this could give rise to a dispute regarding whether any right to terminate has in fact arisen. So how to reduce the risk of litigation? Well, for future agreements, clarity is key. Good drafting is a matter of identifying and addressing how risks will be allocated, both existing known risks and areas of existing or future uncertainty. The same goes for any existing agreements where there's an opportunity to renegotiate terms so they remain fit for purpose in the post-Brexit landscape. Where this isn't possible, and where a dispute does arise, early and effective management of any dispute, having a clear picture of the legal merits and the underlying commercial dynamics, can help to avoid the costly distractions of litigation. I'm now going to hand over to Tim on product regulation.
Hello everyone, thank you Stuart. So we've had a run through of some of the complex trade and disputes related aspects of the movement of products across the EU and UK. From a product regulatory point of view, businesses have of course been used to decades of close regulatory alignment between the UK and other European countries. But there has naturally been some concern about the implications of any post-Brexit misalignment and the cost to business of entities having to comply with both EU and UK regulatory regimes. There are many examples of sectors where this is a sensitive area, but the chemicals sector draws many of the challenges out very well. Two of the most significant pieces of legislation in the chemicals sector are the REACH regulation in relation to registration, evaluation, authorization and restriction of chemicals, and the CLP regulation on classification, labeling and packaging. Now, as many of you will know, the approach to EU law generally, and David mentioned this earlier, has been to replicate EU law at the point of leaving the EU into UK law, creating a body of retained EU law. This doesn't, however, mean that the impact of such laws remains the same as was the case prior to Brexit. Oversimplifying and setting aside the tax and trade considerations that have been discussed, EU chemicals legislation now treats chemicals imported from Great Britain to the EU in the way it would previously have treated chemicals imported to the EU from a non-EU country such as the US. Great Britain now does the same in respect of chemicals imported from the EU. Some rules, of course, have been put in place in Great Britain to try to make things easier, at least for the time being. EU has not necessarily reciprocated. So in the present scenario, chemicals are brought into GB from the EU. Previously, GB countries could take advantage of EU REACH registrations, but now any company manufacturing or importing a substance or mixture and placing it on the GB market must have a GB REACH registration. EU REACH registrations held by GB companies at the time of Brexit have been transferred over into UK law, though some administrative steps still need to be dealt with. Companies have 2, 4 or 6 years plus 300 days from the 1st of January of this year to provide the remaining data to complete the registration process. And the exact time frame is dependent on the volume placed on the GP market and the hazardous nature of the substance in question. On a separate note in respect of CLP, the requirement to undertake a classification and labelling notification has also been brought into UK law in respect of Great Britain, with any substances notified by UK companies using the EU system by December the 31st, 2020, automatically being brought across into the GB system. Any new chemicals that require notifying after this time will be required to use the new UK portal. Where the raw material is then used to create a substance in Great Britain, which is sold to the EU, the UK entity will need to register the substance within the EU in accordance with EU REACH. To do so, it could use an only representative established in the EU. The UK entity can also relocate or set up in the EU to make the registration, or the EU importer itself can register the substance. You'll notice I've been referring to GB rather than UK. This is because the situation is further complicated by the fact that under the Northern Ireland Protocol, the EU REACH and CLP legislation continue to apply in Northern Ireland, but not in Great Britain. So a substance brought from the EU to Northern Ireland is not subject to UK REACH registration requirement, and the substance exported from Northern Ireland to the EU can benefit from pre-existing EU REACH registrations. On the other hand, the regulatory regime that will apply in respect of chemicals moved from Great Britain to Northern Ireland is similar to that which will apply when moving chemicals from Great Britain to France, for example. There are some additional quirks to be considered. Much of the analysis of what law applies to products in which jurisdiction hangs on whether the legislation was actually in application at the time of Brexit, and is therefore grandfathered by way of the concept of retained EU law. So legislative requirements included in EU law on the 31st of December, but set to apply in the future, are not automatically brought into UK law. A good example of this is the Poison Centres Regulation, which adds an annex to the CLP regulation. Poison Centres Regulation is not in force in Great Britain. From a practical perspective, the kinds of issues that this gives rise to from a product regulatory standpoint include things like the need to rethink supply chains and movement of products, need to enter into agreements with people to make registrations, get access to the relevant documentation that's needed to be able to do so, and the cost and administration of double regulation. A very important further issue to look out for will be the need to keep up to date with legislative changes in both jurisdictions instead of just one. Now over to my colleague Chris.
Thanks, Tim. I'm going to talk about financial services, and I thought for my piece we might expand our fact scenario a little bit. So let's say our UK chemicals company has a very important and long-standing business relationship with a German insurer. And the German insurer helps out our UK company in a number of areas. Importantly, it's the lead insurer on all of its most valuable business insurance policies. So let's say for its property insurance for its plant and equipment, and its business interruption insurance if things go wrong with that plant and equipment, and its liability insurance. And the German insurer is not the only insurer on these programs, but because it knows the company well and has been dealing with it for a number of years, it has confidence to underwrite it, offers good premiums, and the UK company's impression is that it has really helped in past years to get other insurers involved on the program on good terms as well. And the other area this German insurer helps out is in relation to the UK company's trade finance arrangements. So the UK company, like a lot of other firms, participates in an arrangement which is backed by banks and insurers, which helps it to secure early payment of its invoices. It's really valuable for the company and important for the way it operates, because it means it can get a faster and more reliable and predictable income stream. And again, the German insurer, the value of their involvement in this is it knows the company well, and it's prepared to participate in that scheme. And the company's perception is, that gives confidence to the rest of the market operating. So for all of these reasons, the role of head of insurance at our UK's chemical company is really important. And let's imagine ourselves 100 days out from Brexit, and the head of insurance receives a phone call from their key client contact at the insurer, the German insurer. And the phone call doesn't start well, because the client contact says, look, I'm really sorry, but we've had some difficult board meetings recently, and I'm actually ringing to say that I'm afraid we're going to have to end our long-standing relationship, and it's all to do with Brexit. And the UK company's head of insurance says, well, this is terrible, and I don't really understand it, because this Brexit took place 100 days ago, and I thought we'd sorted this all out. Didn't you didn't you participate in the temporary permissions regime in the UK? And I thought that gave us at least 3 years, didn't it? And the German insurer says, well, yes, we did. I mean, very early on, you might remember we submitted our notice into the UK regulators, and that did allow us to keep operating as we had previously, relying on our passports. And it's true that regime lasts for 3 years, but actually how it works is partway through the process, the UK regulators, will approach you and say, look, the time has come now for you to submit your full application to permission to keep working in the UK once the temporary permissions regime ends. And a month ago, the UK PRA approached us to do that. And we've been looking into that, and that's what's caused the problem. And the head of insurance says, but I do remember that now, but I also remember that after we talked about that, the UK granted equivalency to European insurers, I thought, because I remember we talked about that at our end internally, and we understand that it only works in one direction. So we understand it's not being reciprocated by the EU. So UK insurers wanting to operate in Europe might have problems, but we thought it all did work in the other direction. So we thought the UK had offered equivalency for European insurers operating in the UK, but you're saying you still need to submit an application for authorization. And the German insurer says, yes, that's true. And we do still need to submit a full-scale application. And actually, now that we've sat down and talked about it, we really have realized that, life under this new regime, even with equivalency, is going to be quite different from how we're operating at the moment. I mean, look, equivalency is helpful, but it only covers some quite narrow areas of the insurance regime. So our difficulty is it's going to be much more difficult and expensive to operate in these two separate jurisdictions going forward. And of course, like everyone else, we are a little bit concerned about the difficulties and the possibility that there might be a divergence of the regimes later on. And we've thought very hard about it, and we've just decided we can't afford to continue to operate in the UK. So I'm afraid we're going to have to end our relationship. Now, we are able, with the UK regulators' approval, to wind down the business in an orderly way. So we don't have to stop being your insurer immediately. But when all of your policies renew in 6 months, I'm afraid we won't be able to participate. So this is a problem for the head of insurance in the UK, and they hang up the phone and they think, oh my goodness me, I've got quite a big project ahead of me, a bit worried about the uncertainty. And they think, well, I wonder if, in the early days of my career, when I had the opportunity to move into HR, if I should have taken that opportunity. And they think, I wonder what sorts of considerations my counterparts in HR are now thinking about. And with that, I will hand over to James, who's going to talk to us about international mobility.
Thanks. I'm now going to talk about the global mobility aspects, international mobility aspects of this scenario. So the first thing to remember in all of this is that all British and non-Irish nationals require immigration permission if they wish to enter the UK. Now, the good news is that if they're coming in just for a business visit, they do not require a visa. So they can literally apply for immigration permission to enter the UK on entry when they arrive. Now, if Company A wants to send individuals over to the UK to meet with Company B, they can certainly do that as a business visitor. That is a permitted activity for business visitors. They also may undertake certain other activities as business visitors. But the main thing that must be remembered is the fact that business visitors cannot undertake productive work in the UK. Now, there are exceptions to this. There are certain activities that business visitors can undertake in the UK, which would normally be classed as work. So, for example, if Company A is sending individuals over so that they can be briefed on Company B's requirements. So, what is Company B using this raw material for? So that they can make sure that they supply the right type of that raw material. And if Company A representatives are going over to negotiate and sign a contract with Company B, that they can do. Company A employees can also travel to the UK in order to deliver the product to Company B. So, as I said before, they cannot undertake productive work whilst they are in the UK. that may, for example, so one thing they cannot do is they cannot provide, company A employees cannot provide to company B employees advice on, say, the appropriate way to use product X in the manufacture of product Y. So they cannot do that. Therefore, before a company based in the EU sends EU national employees to the UK on business visit, it's very important they check to make sure that the activities that they were going to be undertaking are permitted for business visitors. In the same way, if company B wants to send individuals out to company A to look at this raw material to make sure that it is fit for purpose, then again, they need to make sure that the activities that they are going to be doing in the jurisdiction within the EU, that those activities are permitted for visitors. Now, the complicating factor with this is that each EU country has different rules around what is a permitted activity for a business visitor. Now, as a rule of thumb, it is absolutely fine for individuals to travel from the UK, say British citizens, to travel from the UK to the EU to go to one-off business meetings. But if the activities that they are going to be doing are more involved with that, it is really important to check to make sure that those activities meet the requirements, or the visitor requirements for that particular EU country. Now, say in the scenario where a company B, they are manufacturing this product in the UK, and actually they want to expand their operations in the UK. And by expanding them, they are actually need to recruit more people to work in the UK. Now, because they are using product X, what they need people who are experts in manufacturing products using product X. And actually, as product X is mainly manufactured and made in the EU, they are actually going to need to look to employ EU nationals in the UK because those are the people with the expertise for using product X. If they want to do that, then it is highly likely that the UK company, so company B, is going to need to apply for a sponsor license in order to be able to sponsor those EU nationals to come and work in the UK, because those EU nationals will need immigration permission in order to undertake that role. That application has to be done before they come to the UK. In order for company B to get a sponsor license, it must demonstrate that it is established and trading in the UK, has a genuine need to recruit migrant workers, and has the policies and processes in place in order to monitor those individuals. Sponsor license applications can take between 2 and 8 weeks to be processed. So if this is something that company B are thinking about doing, they need to think about doing this sometime in advance. It's not a good idea for them just to wait until they find out that they've actually got someone they need to sponsor. It's a good idea to obtain that license in advance of actually having the need to hire someone. One of the important points to remember when a company is looking to sponsor individuals to work in the UK is that that individual must be able to communicate in English to the required level. That can normally be demonstrated either by the individual being a national of a country which is deemed to be English speaking, or if they have got a degree level qualification or higher, which was taught in English. Now, unfortunately, EU countries, with the exception of Malta, none of the EU countries are deemed to be English speaking. So therefore, it is highly likely that individuals will need to undertake an English language test in order to demonstrate that they can communicate to the required level. Unsurprisingly, with COVID restrictions in place at the moment, there are restriction on individuals taking those tests. So it's important that migrants plan and factor in the time it will take to take this test before they can apply for their visa. So in conclusion, the two things to really take away from this is that UK and EU companies must be more aware of the immigration considerations which they need to think about when doing business with each other. And it's really important for companies to remember that when they're sending individuals from the UK into Europe and from Europe into the UK on business trips, that they make sure that the activities those individuals are doing are permitted for business visitors. And I would now like to hand over to David, who will talk about subsidy control.
For some of the reasons just discussed, the owner of the plant decides that it would like to expand its UK capacity and wishes to obtain UK government support for this. It's also considering a potential equity investment by an overseas partner. I'm going to touch on 3 new or proposed new areas of law, all currently at different stages of the legislative process. 2 of these are not a direct consequence of Brexit, but will be potentially an important part of the post-Brexit legal landscape for businesses active in the UK or doing business with it. First, the new UK subsidy control regime. The existence of a level playing field in relation to government subsidies was a major sticking point in the final stages of the Brexit negotiations. The outcome was a set of principles set out in the TCA that require the UK government to put in place a new subsidy control regime. That regime will have many similarities to the existing EU state aid regime, but there will be important differences. The principles in the TCA are supplemented by specific principles on key sectors and types of aid. Those provisions have been implemented by the EU Future Relationship Act 2020, and a subsidy control bill was announced in the Queen's speech this month, but has not yet been published. The main means of challenging potentially unlawful subsidies under the new regime would be by means of judicial review after grant of the subsidy. This is in contrast to the regime of the EU, which requires prior notification and authorization. And it remains to be seen how this will work in practice. In particular, it's presently unclear how sufficient legal certainty would be available to beneficiaries, sponsors, and lenders in the case of major investments. And for subsidies in general, it's unclear what type of exemptions and guidance will be available. In the meantime, companies that are contemplating receiving aid from the government need to be in a position to certify the compliance of the aid with the principles set out in the TCA. This presents some practical issues. In many cases, in fact, the best available guidance is the old body of rules and case law under the EU state aid regime. This might in practice cause companies and granting authorities to take an expansive view of what is in fact currently permissible. But this also creates a risk of challenge by competitors. And even in relation to pre-existing aid, we're seeing efforts now to police the compatibility of the way that aid is being dispersed that had been granted prior to the 31st of December 2020. That aid being still subject to review by the European Commission. So ultimately, if the EU considers that the UK is not abiding by the commitments in the TCA, it would be possible to invoke a settlement mechanism. And this could lead to unilateral remedial measures and the use of a rebalancing mechanism to protect the level playing field. And furthermore, under the TCA, the EU state aid regime still applies to subsidies affecting trade in goods, as well as wholesale electricity between Northern Ireland and the EU. Second, in a major development this month, the European Commission published a draft regulation on foreign subsidies. The draft regulation, if adopted in its present form, would permit the Commission to take action in relation to distortive subsidies, including subsidies granted up to 10 years before entry into force of the new regime, if they have a continuing impact. And this is likely to give rise to significant legal uncertainty and complaints over time. Mergers and joint ventures involving entities that benefit from foreign subsidies will be subject in certain cases to specific provisions drawing heavily on EU merger control, including mandatory notification. The draft regime also provides for the possibility of market investigations and will allow the Commission to take action based on the facts available, as the Commission may in practice have difficulty obtaining relevant information. This is certainly an area to watch and could potentially in due course be relevant on the facts of our case study if the proposed subsidy could have effects within the EU. Third, turning now to the possibility of an equity investment by an overseas investor alongside government support. Following the grant of royal assent on the 29th of April, a new UK National Security and Investment Act will enter into force later this year. It provides for mandatory notification and prior approval of certain acquisitions of control of entities active in a number of sensitive sectors. In a significant change from the bill published last November, the government has removed the lowest of the thresholds, which was to be 15%. The lowest threshold is now 25%, but it means that on the facts of our case, if the overseas investor takes a 25% equity stake, this might be subject to prior notification and approval, with the possibility of criminal sanctions for companies and individuals if it fails to notify and obtain the requisite approval. In relation to transactions entered into since publication of the bill last November, or indeed currently under negotiation, there's a question of allocation of the risk of a retrospective review of those transactions once the Act enters into force. The scope of the sensitive sectors was narrowed during the consultation but remains broad, and on the facts of our case, this could, for example, extend to advanced materials such as polymers and coatings, as well as chemicals with defense or dual-use applications, such as certain advanced textiles. Notifications will be made to the Department for Business, Energy and Industrial Strategy, or Baines. In addition to the mandatory notification provisions, there's a 5-year retrospective review power for other acquisitions of control in non-sensitive sectors, as well as certain acquisitions of assets. The Act will also be applicable to various transactions falling outside standard M&A. For example, we've been considering its impact on lenders in relation to security enforcement and restructuring. In conclusion, and looking ahead, the TCA will present many opportunities and challenges for businesses. The existence of the TCA, as opposed to the alternative of a no-deal Brexit that we were considering as late as last December, is of itself significant, as it means that there is scope for the UK and the EU to build on the current regulatory framework in key areas, and this may be relevant to long-term investment decisions. Regulatory divergence is, of course, at the heart of Brexit for the UK government, but it remains to be seen how far the government will avail itself of this. And it's not yet clear whether, and if so, how the remedial and rebalancing provisions relating to the level playing field will be deployed in practice. Finally, the EU Future Relationship Act contains a catch-all implementing provision, section 29, giving effect to our existing domestic legislation with the modifications required to implement the TCA. This very general provision is reported to be a result of the last-minute nature of the trade negotiations, which didn't allow sufficient time for detailed domestic implementation in many areas. As a result, the UK courts and public authorities will have significant discretion in practice in relation to the interpretation and implementation of many provisions of the TCA. This concludes today's webinar. We hope the information shared was useful. Thank you very much for your participation.